Ang lahat ng mga empleyado na nagtatrabaho dito man o sa labas ng bansa ay may mga karapatang nakalathala sa batas. Ilan sa mga ito ay ang pagkakaroon ng seguridad sa trabaho at pagtanggap ng karampatang sahod.
Kasong tatalakayin natin ngayon, mayroon nga bang sapat na kapangyarihan ang ilang ahensya ng pamahalaan na mamagitan sa kasong naganap sa labas ng bansa? Ang kawalan nga ba ng tiwala ng isang employer sa empleyado nito ay sapat ng dahilan upang tanggalin ito sa posisyon? Ito ang sasagutin ng ating kaso ngayon.
The case that we will digest for today is coming from the General Register number 157376. The two parties involved are Corazon C. Sim as the petitioner and the NLRC and the Equitable PCI Bank as the respondents. In this video, we will highlight the facts, the issues, and the ruling of each court. The story began in 1990 when Corazon Sim was initially employed by Equitable PCI Bank as an Italian remittance marketing consultant. Eventually, she was promoted to a managerial position. But on September 1999, she received a letter from Remigio David, the senior officer, European head of PCI Bank, and managing director of PCIB Europe, informing her that she was being dismissed due to loss of trust and confidence based on the alleged mismanagement and misappropriation of funds. The respondent, on the other hand, denied any employer-employee relationship between them and sought the dismissal of the complaint.
The issue in this case is whether or not the petitioner was illegally terminated from her position in Equitable PCI Bank.
Labor arbiter rendered its decision dismissing the case for want of jurisdiction and or lack of merit.
According to the labor arbiter, the labor relations system in the Philippines has no extraterritorial jurisdiction, since complainant was hired and assigned in a foreign country. Although by a Philippines corporation, it follows that the law that governs the relationship is the law of the place where the employment was executed.
Okay, so since the case was dismissed by the labor arbiter due to their so-called lack of jurisdiction, did Corazon file an appeal on the NLRC?
The petitioner filed an appeal on the National Labor Relations Commission. Later on, the NLRC affirmed the labor arbiter's decision and dismissed the petitioner appeal for lack of merit.
On October 29, 2002, the Court of Appeals dismissed the petition for certiorari due to petitioner's not filing of a motion for reconsideration with the NLRC. The petitioner filed a motion for reconsideration but it was nonetheless denied by the CA.
Oh, wait. Hold on. Is the motion for reconsideration really necessary before filing a petition for certiorari?
Well, actually yes, because a motion for reconsideration is a prerequisite of a petition for certiorari. There are two rules of court that have been mentioned, the Rule 45 and the Rule 65.
Under Rule 45 of the Rules of Court, regardless of the nature of the action or proceedings involved, decisions, final orders, or resolutions of the Court of Appeals may be appealed to the court by filing a petition for review. While a petition for certiorari under Rule 65 is not an appeal but a special civil action restricted to resolving errors of jurisdiction and grave abuse of discretion, not errors of judgment. This is to give the lower court the opportunity to correct itself. This rule has few exceptions, but the petitioner failed to qualify her case among these.
Furthermore, the petitioner argues the following. First, is filing a motion for reconsideration with the NLRC is useless. Second, the issue at bench is purely a question of law. Third, the petitioner questioned the ruling of the NLRC sustaining the labor arbiter's conclusion that she was validly dismissed by respondent. On the first argument, it is not a duty of the petitioner to determine whether filing a motion for reconsideration is necessary or not. It is only in the manner and is strictly in accordance with the provision of the law and the rules. For the second argument, the issues raised in this case are actually a mixed questions of fact and law. A questions of fact emerge when there is a doubt as to the truth or falsity of the stated facts, and a question of law arises when there is a difference as to what the law is on a certain set of facts. And thirdly, since the respondent denied that there was an employer-employee relationship, the legality of the petitioner's dismissal hinges are still being assessed.
For another substantial evidence, the petitioner did not deny having withdrawn the amount of 3 million Italian lire from the bank's account and stated that the said amount was used for the radio program of the company. However, the respondent countered that at the time she withdrew the money, the radio program was already off the air. So in here, we can notice two contradicting statements coming from our petitioner and the respondent. So yun naman pala, hindi naman nag-deny itong ating petitioner na si Corazon na nag-withdraw siya ng tumataginting na 3 milyong Italian lire mula sa account ng bangkong pinagtatrabahuhan niya. And her reason? Para gamitin ang pera sa ongoing radio program ng kanilang kumpanya. But then, nag-oppose itong ating si respondent saying na yung time na nag-withdraw itong si Corazon ng pera, off-air na pala itong programang tinutukoy ni Corazon. So the mere fact na nagiging alanganin na ang tiwala nitong employer sa kanyang empleyado na si Corazon, it is enough reason for PCI Bank to dismiss Corazon from her position.
After reviewing all the angles of the case, the court rendered a decision to deny the petition. Cause against the petitioner. Here's what happened.
The court noticed that the labor arbiter committed an error when it dismissed the case due to lack of jurisdiction because according to Article 217 of the Labor Code, the labor arbiter shall have original and exclusive jurisdiction to hear and decide cases such as termination disputes.
Moreover, Section 10 of Republic No. 1842 or the Migrant Workers and Overseas Filipinos Act of 1995 also provide that the labor arbiters of the National Labor Relations Commission, NLRC, should have the original and exclusive jurisdiction to hear and decide the claims arising out of an employer-employee relationship or by virtue of any law or contract involving Filipino workers overseas deployment, including claims for actual, moral, exemplary, and other forms of damages.
Under these provisions, it is clear that labor arbiters have original and exclusive jurisdiction over claims arising from employer-employee relations, including termination disputes involving all workers, among whom are overseas Filipino workers.
Considering the labor arbiter and the NLRC's factual findings as regards the validity of petitioner's dismissal and with the presence of substantial evidence, there is no compelling reason for the court to relax the rule, prohibiting the filing of a motion for reconsideration before filing a petition for certiorari.
Makikita natin sa naging kaso ngayong araw ang kahalagahan ng pagiging matapat sa tungkulin. Ang pagbahid ng personal na interes, lalo na kung may kinalaman sa pinansyal na aspeto, ay maaaring magdulot ng kapahamakan tulad na lamang ng pagkatanggal sa trabaho. Ang pagiging isang empleyado ay hindi lamang may kaakibat na responsibilidad, kundi kasabay din ito ang tiwalang ibinibigay sa atin ng ating mga katrabaho, amo at iba pang mga taong nakapaligid sa atin. Huwag sana nating bahira ng ating reputasyon ng pagkasilaw sa salapi, bagkus panatilihin ang katapatan sa anumang uri ng sitwasyon. Kayo ay nakatutok dito sa Justice Makers, because in justice, we trust. Hanggang sa muli.